Hello friends, welcome to Riddhi Legal. Today we will discuss the important MCQ on Indian Contract Act 1872 on the topic promise and consideration. So let's begin. The first question is, a proposal when accepted becomes A. Promise, B. Agreement, C. Contract, D. Acceptance. This question was asked in the MPCJ in 2015. The correct answer is answer A, that is promise. Section 2B of the Indian Contract Act provide that when a person to whom proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal when accepted, it becomes a promise. The next question is, to convert a proposal into a promise, the acceptance must be A. Absolute and qualified, B. Absolute and unqualified, C. Unusual and reasonable, D. Usual and qualified. The correct answer is answer B, that is absolute and unqualified. This is because Section 7 provides that in order to convert a proposal into a promise, the acceptance must be absolute and unqualified. This was asked in the Gujarat preliminary examination in November 2019. The next question is, if a proposal has been accepted subject to certain conditions, then A. the contract is valid and conditions are binding, B. the contract is voidable, C. the contract is valid but conditions are not binding, D. the contract is not constituted at all. So, the correct answer is answer D, that is the contract is not constituted at all. This is because to convert a proposal into contract, there should be absolute and unqualified acceptance as required in Section 7. This was asked in the Himachal Pradesh Judiciary Examination 2011 and also in Bihar 2016. The next question is, according to Section 2C, promisor is the A. person who accepts the proposal, B. person to whom proposal is made, C. person who makes the promise, D. person who makes counter offer. The correct answer is option C, that is person who makes the promise. Section 2C provides that the person making the proposal is called the promisor and the person accepting the proposal is called the promisee. This was asked in the Jharkhand in 2014 judicial examination. The next question is, this question is regarding consideration. Which of the following sections of the Indian Contract Act defines consideration? This is the most asked question in various examinations, and the options are Section 2A, Section 2B, Section 2C and Section 2D. The correct answer is Section 2D defines the consideration, which says that when at the desire of the promisor, the promisee or any other person has cloned or abstained from doing or does and abstains from doing or promise to do or abstain from doing something, such act or abstinence or promise is called consideration for that promise. So this was asked in the Jharkhand in 2014 and also in judiciary examination of the MP in 2013. The next question is, A promises to maintain B's horse and B promises to pay A rupees 1000 yearly for the purpose. This consideration is A. lawful consideration, B. partial consideration, C. illegal consideration, D. not a consideration at all. So, the correct answer is answer A, that is lawful consideration, because there is a mutual consideration and it is a lawful one. The next question is, which of the following subject matter is dealt under the case law Chinnayya Vs Ramayya? Options are A. offer, B. capacity to contract, C. consideration, D. damages. ये क्वेश्चन आप लोगों को टॉपिक वाइज से भी पता चल गया होगा कि द राइट आंसर इज C. Consideration. In Chinnayya Vs Ramayya, it has been considered as the consideration part. The next question is, which of the following statement regarding consideration is not correct? A. It must be given at the desire of the promisor. B. It may be passed also. C. It need not be adequate to the promise. D. Stranger to it cannot sue. This was asked in the UP-PCSJ in 2012. The correct answer is C. That is, it need not be adequate to the promise, because consideration need not to be adequate according to the promise. So the next question is, promissory estoppels is sometimes spoken as a substitute for A. Quasi contract, B. Consideration, C. Coercion, D. Novation. The correct answer is again consideration, that is option number B. This is according to the American jurisprudence, which mentioned that promissory estoppel is sometimes spoken as the species of consideration or as a substitute of the consideration. So the next question is, following is a case on promissory estoppel: A. Kedar, Nath vs Gorie, Mohamed. B. Delhi Cloth and General Mills Limited vs Union of India. C. Both A and B. D. None of the above. The correct answer is C. That is both A and B. Kedarnath vs Gorie, Mohamed, and also the Delhi Cloth and General Mills Limited vs Union of India. In this case, it was the both the cases are related to the promissory estoppel. This was asked in the UP PCS judicial examination in 2018 and also in Himachal Pradesh in 2016. The next question is, a consideration may be A. Executed, B. Executory, C. Past consideration, D. All of the above. The correct answer is D. That is all of the above. Consideration may be executed, executory, past consideration. In India, unlike English law, executed, executor and past, all types of consideration is valid. This was asked in the Delhi JLO and ALO examination 2016. The next question is, executory consideration: A. Consists of a promise in future. B. Liable in outstanding on both the parties. C. A promise for a promise. D. All of the above. The correct answer is all of the above. Executory consideration is in the fact a promise for a future. In executory consideration, the liability is outstanding on both the sides. This was also asked in the Jharkhand in 2018 and also in Delhi in 2016. So this was the last question of this series, and I hope you really like the video, and do share this video to everyone, and आप लोग साथ ही साथ उसको solve करते रहिएगा. My next series will come soon. Thank you till then.